this time of day. Birthdays and anniversaries, especially those ending in 0, put people in a reflective mood. And I recollect as I approached my 40th and 50th and 60th and soon my 70th birthday, I found myself thinking about my past, figure out what went wrong. There was always something that went wrong, and what went right, and how I could fix that, which was fixable, and learning to live with that, which was not. Mindful of the old adage that you have to know, have the wisdom to distinguish between the two. Anniversaries of cases have that same power of encouraging retrospection. And just as people change, so do cases. And in fact, it's quite rare that a case remains unaltered by subsequent decisions. Because by their very nature, cases expand and contract and wrapping an opinion around slightly different facts and different times, and new justices inevitably makes new law. And in fact, cases change even if they are never spoken about again, such as when the court does not apply them or cite them in a situation clearly calling for their invocation. And even without a funeral, the glaring omission is a clue that the case is dead, dying, or at least limited to its facts, and ditto for dishonest distinctions. Irene Gault was rendered at the height of the Warren Court's activism that brought many doctrinal shifts, particularly in the criminal procedure area. Gault was decided in 1967. Gault, notwithstanding what Professor Mintz said, conceptually, legally, Gault seemed to come out of nowhere, like, hello? What am I building on? In all the criminal procedure cases, what the court did is go from rules, from standards to rules, but they already established the base. There was a right to counsel, albeit under the Due Process Clause, and simply moved into the rule of the Sixth Amendment requires counsel in every felony case. But Gault didn't have that base. Now it's true. The year before, in 1966, in the Kent case, the court had held that due process applied to waiver hearings in juvenile court, waiver hearings which send children from juvenile court to adult court. But I don't count that so heavily because we weren't even sure if Kent was of constitutional dimension at the time it was decided. At the least, let me say that Kent did not inexorably call for the Gault decision because Kent dealt only with this very narrow slice of the court's jurisdiction. And all the court held in Kent was that due process required a hearing, the right to counsel, access to the records, probation files, and a statement of reasons for waiving the child. Gault, on the other hand, dealt with the very core of the civil, in quotes, juvenile courts. And the hearing, the decision, was a very narrow decision. Here's what the holding is. At the adjudicatory or fact-finding hearing to determine if the minor was delinquent, that is, a child who committed an act which, if committed by an adult, would constitute a crime, then the proceedings had to adhere to certain due process rules. Prior to Gault, the fact-finding proceedings, the adjudicatory hearings in juvenile court, bore no small resemblance to the literary trial that was conducted by the Queen of Hearts, sentence first, verdict afterwards. And Justice Fortas in Gault, like Alice in Wonderland, responded stuff and nonsense. To truly understand Gault, you had to read all those footnotes, because a lot of what the court was not doing was hidden in the footnotes. All it said, the case, was that at this adjudicatory hearing, the child was entitled to notice, assistance of counsel, the right to cross-examination and confrontation, and the privilege against self-incrimination. The rights to notice, counsel, and cross-examination were all contained in the Sixth Amendment and had been incorporated into the due process clause of the 14th Amendment already, and thus made applicable to the states. However, in Gault, Justice Fortas did not invoke the Sixth Amendment. He invoked due process, the fundamental fairness due process, not the due process which has incorporated all of the guarantees almost of the Bill of Rights. And that strategy enabled the majority to say that these hearings in juvenile court need not conform to all the requirements of a criminal trial, or even of the usual administrative hearing, which is very low-level due process. However, the court cleverly, and Fortas was a master at this, obfuscated the underlying constitutional basis for the decision, ambiguously asserting neither the 14th Amendment nor the Bill of Rights is for adults alone, and then going on to explicitly grant the privilege against self-incrimination in the Fifth Amendment. In other words, he didn't grant the privilege against self-incrimination as a matter of due process. He gave it to them as a matter of the Fifth Amendment. And this suggested a kind of selective incorporation theory. Now, I read Gault, foolishly, as it turns out, but I read Gault in terms of the applicability of the rights and in the content of the right. Permit, at least, enhanced protection, constitutional protection for children. Due process is flexible, and the result depends largely on facts and circumstances. And you can make the argument, I know Professor Mintz doesn't agree with it, that children would need more constitutional protection than adults, and that is not an insane view of the law, because if you think about it, the adjudicatory hearing is the same as a criminal trial. Did he do it? He's charged with an offense, and the question is he guilty? And the court itself said the delinquency adjudication was comparable in seriousness to a felony prosecution. However, although the hearing and the criminal trial might be functionally equivalent, in my view, the adult and the child are not. And I thought that Gault could be read that to provide extra protection for children to overcome competency differentials, and they are different from grown-ups. I tried those cases.